Welcome everyone to another edition of MHQ's Foundation 101 podcast, where today we are very excited to be joined by David Russell QC. David, good morning.
Good morning, Jan.
And today we do not talk something specific about Foundation technically, but we have very exciting news in for a change, a judgment that was rendered by the DIFC Court of Appeal. And together we will discuss what is its impact for end users in the DIFC. And as we will see, it is a paramount piece of documentation. So maybe before we go into some of the key takeaways of this judgment, can I ask you, what is a request for interpretation? Because I understand this judgment followed such a request.
Yes, it did. In general, courts don't like to issue what are called advisory opinions. Courts like to have a situation where you have two parties fighting over what the facts are and what the law, how the law will apply to those facts. So courts in many countries, for example, in the United States or Australia, don't even have jurisdiction to give advisory opinions. Courts often have it in the context of constitutions. For example, in Malaysia and Ireland and Singapore, there's a capacity for a court, if asked by a government, to answer a question about what the law really means. Yep. Canada is probably the most advanced jurisprudence, but we have that capability in the DIFC, and indeed in all the international financial centres. You find the same thing in the Abu Dhabi Global Market, in the Astana International Financial Centre. Because these are new jurisdictions without much experience of common law, so it was felt to be a useful adjunct to get the system up and running.
So this is why this is so important, because it gives also confidence to the end user, I guess. So why do you feel, and so do I, that this judgment is so important?
Well, I think there are two aspects to that. The first, in a sense, is it didn't really matter what the judgment said. The concern that was often expressed, and it was expressed to the DIFC Wealth Management Review, which I chaired, was that users didn't really know how a court would approach trust matters. People would say, we don't know what the court will do in the event of a dispute. And the principal takeaway from this judgment is that we know now how a court will approach trust matters. And that is, it will approach them in a totally conventional way, in the same way the court would in England or in Australia or in Canada. It is in that sense, it gives a great deal of confidence that you can rely on opinions and precedents that have been developed elsewhere in the world to work out how your trust will operate and how a court will deal with it within the DIFC. The second point is that the court spent a lot of time analysing what I'll call the local framework.
Yes.
And that's important because one often hears people say, trusts are somehow foreign to the region, which I've always found a bit ridiculous, because in fact, the first trust came from this region, and on one view, it was established by the Prophet himself. The Islamic concept of Uqaf is very similar to the common law concept of the trust. And the court analyses that in some detail, points out the similarities, so that people here who have a regional background needn't feel this is some sort of exotic European import. It in fact is something which reflects their own traditions going back for very much longer than Europe had the trust.
Yeah, very interesting. So if you agree, let's jump on some of these key takeaways that we have taken out and highlighted. And to me, most of them are very practical, and they should, as you mentioned, provide confidence to end users. So let's look into that. One of the first questions that was asked and that the court actually clarified is whether if a property is settled onto a DIFC trust and that property is actually located elsewhere, outside of the center and outside of the country, is this still possible? Is it recognized under a DIFC trust? And the answer, as you will elaborate upon, is yes.
That's correct. This, interestingly, was an issue that was never formally resolved at senior appellate level in England until a few years ago. Again, in a case involving this region called Acres and Samba, which you'll recognize from the name is a bank in the Kingdom of Saudi Arabia. But here, there's always the issue of the special limited jurisdiction of the DIFC. So it might have been argued that you got a different answer here to what you would get in England. But what the court has said, and has said very clearly, is that there's no restriction either on the location of the property or whether or not the property is in a jurisdiction which recognizes trusts. And that's a perfectly logical response, because a trust is a personal obligation in respect of property imposed on a trustee. So the real question is where the trustee is.
Yep.
And can the court make orders which will bind the trustee to comply with them? And unsurprisingly, the court said that the answer to that was yes. So that becomes important, particularly in the context of the new federal trust law, which makes a distinction between DIFC trusts and ADGM trusts on the one hand, and foreign trusts. It's clear now, I think, that a DIFC trust can include trust property, which is within the United Arab Emirates, but outside the financial free zones.
Yeah, and that is a key aspect. Now we'll see whether the land department starts to get educated, and we think it will over time, to actually recognize trust the same way they recognize foundations. That is music for the future. Now the second question, which I thought was very, very topical, is we know today that a foundation can hold property as a foundation asset, so an asset that is part of its P&L that has to be settled onto it. But one of the questions that was asked was whether a foundation could hold property effectively as a trustee, something that often we see in practice in the context of private trust companies. And here the answer was?
Yes, indeed. The reason for the question arising is that it was important in drafting the foundations law to make it clear that a foundation was not a trust, and therefore there was a provision that said that the foundation didn't hold its property in trust for anyone. And that raised the question in the minds of some people whether or not there was a prohibition on foundations acting as trustee. The court correctly, in my view, was very much the submission of the DIFC authority. The court took the view that the foundation could hold property as trustees. So a foundation can obviously conduct its activities as a foundation, but separately it can be the trustee of a DIFC trust, or indeed any other trust.
Which is consistent with the practice, because we have worked already on files, both of us, on foundation, both in the DIFC and in the AGM, that actually act as a trustee. So this was just a confirmation for the greater good. One important point is that if a foundation is to indeed act as a trustee, then it is paramount that the charter, respectively the bylaws, are adjusted accordingly, so that this be reflected in the documentation as to these assets not being part of the P&L of the foundation, not becoming foundation's assets. Another question that was asked sounds a little bit technical, but it's something that has been coming back and back and back again, is that whether the reference in the trust law to the common law of trust and principles of equity includes or is limited to the law of England and Wales. Perhaps you can just explain this issue and what it means in practice, and then elaborate on the answer.
Well, the starting point is the DIFC trust law is modeled on the United States Uniform Trust Code. It is an attempt to very much more comprehensively deal with issues relating to trusts than, say, a conventional trust law or trust act in the United Kingdom. So there was, first of all, the question of the extent to which jurisprudence from outside the United Kingdom could come into play. As you know, the default law in the DIFC is the law of England and Wales. So the question was, first of all, whether the fact that the DIFC trust law was based on the Uniform Trust Code meant that one didn't look at the law of England and Wales in the same way as you might say in a contract dispute. The second point was whether or not, because of the default status of the law of England and Wales, you would look to the laws and the experience of other common law jurisdictions to determine how the DIFC trust law would work. Unsurprisingly, in my view, the Court of Appeal took the view, as it has done, say, in relation to contract law, that this is one of the courts of the common law world. It is entitled to borrow from the jurisprudence of the other great courts of the common law world. But it will obviously be very heavily influenced in that regard by the law of England and Wales, because that is the home jurisdiction of the common law trust.
Yep. So a clear path to I would say legal security, where you can borrow, but you can also improve. So you're not stuck with the old, but you can build up on whatever has been done before. And I think, again, this is a strong commitment to, look, this center is serious, they know what they're doing, and it will enable also the legislation to evolve to, I would call it, them regional specificities, some of which is compliance with Islamic succession aspects, which you will are likely to find much more often here than you will in England and Wales. On that's actually the next question that was asked to the court is, and it will often happen in practice, if a trustee is not a specialist of Islamic succession and he's seeking the advice or relying on the expertise of someone else that is, the question was whether this is acceptable and whether he would be bound by such advice.
This question arises because the general rule is that trustees can't delegate their functions. And a trustee, for example, of a discretionary trust, who's deciding who's going to receive a particular benefit, normally is required to make that decision by himself, taking into account all of the relevant factors. The trust law contains a provision modelled originally on the law of New Zealand relating to advisory trustees. It isn't limited, obviously, to Sharia concepts. It also would apply in the context of investment advice. But the point that is clear is that a trustee who seeks that advice, provided that in all other respects the trustee is acting in accordance with the trust deed and the trust law, is entitled to rely on it, and the trustee's decision can't be attacked on the basis that the trustee has delegated its functions. So it's very useful here, as you say, particularly in the context where many professional trust companies, and for that matter, individual trustees, may have a background in English common law and therefore not be particularly well versed in Sharia concepts. Mm-hmm. If you have a settlor who's concerned that the affairs of the trust will be Sharia compliant, the settlor can be confident that by setting up structures such as a Sharia advisory board, there will be Sharia compliance, and the trustee won't get into difficulties because the trustee complies with advice that it receives from the Sharia advisory board.
So clearly something that we will see a lot in practice, we expect, with a number of regional families making use of DIFC and ADGM tools these days to restructure and optimize their large assets portfolio based locally in particular. Sticking with the team, one question that was asked to the court was whether the establishment of non-Sharia trust by non-Muslims, which is pretty much you and I setting up a trust in the DIFC, and we are in an Islamic environment. So is that against the DIFC public policy? And the answer, to no surprise here, was no. That the aspect of public policy in the DIFC were primarily on the purpose of the trust, but not qualifying on whether it is Sharia or non-Sharia compliance set up by someone that is a Muslim or a non-Muslim. These are aspects that are completely different and non-topical on this question. So I think it was a good thing that the court clarified this question. If only for the fact that it gives confidence to everyone that, okay, this is what we can do, and we can do pretty much almost what we like, pending the purpose of the trust being acceptable and legal.
Yes, but certainly, I mean, it has never been part of the UAE's legal principles that non-Muslims are bound by Sharia. And the point that had arisen, and this is why we have the DIFC's Wills and Probate Register, was that local courts sometimes felt that their obligation as judges was to follow Sharia in relation to succession, even where the estate that came before them hadn't been a Muslim.
Yep.
And this clarifies that aspect of the matter.
Still sticking with the theme, and a very important question. As we know, in the UAE, mainland succession is handled for Muslims by the personal status law. And the personal status law contains a provision which makes some provision void if one tried to, let's say, defraud the inheritance and succession, whether by way of sale, of donation, of testament, or other disposition. And the question was asked whether the transfer of a property by a Muslim onto a trust or a foundation was necessarily voidable. In other words, the simple fact of legacy planning using a DIFC or ADGM tool, in this case the DIFC, is that legal or not? And the answer, so the answer is it's perfectly acceptable, but within reason, right?
Yes. I mean, you obviously have to take into account Sharia inheritance principles, bearing in mind that Sharia inheritance principles apply to inheritance and to dispositions during the period of what is translated from the Arabic expression as death illness. There's nothing in Sharia which prevents a Muslim from making a lifetime gift or heba. It must be an absolute gift, but that being so, a gift to a trust that's appropriate or a foundation that's appropriately established will not fall foul of those principles. And the answer to whilst the court didn't want to give an interpretation of Article 361 of the Personal Status Law, because it's not a law of the DIFC, yep. The answer to the previous question, in fact, gives us, to some extent, the answer. It would only be the purpose of the trust that could result in its being invalidated. And if a Muslim settlor is determined to be Sharia compliant, obtains legal advice from appropriately qualified Sharia scholars to that effect, and then puts his disposition into place, it's very difficult to see how it could be said that his purpose is to not comply with his Sharia obligations.
And if I may, this is very consistent with our practice, where we have already sought for Muslims opinions from the local Awqaf authorities to pretty much deem structures Sharia compliant. So what the DIFC Court of Appeal here said is exactly the same thing, is as long as the content of the intent is sound and does not go against the law of the land, then no problem. You can structure through a foundation, a trust, and ensure business continuity, intergeneration, legacy planning using a trust or a foundation in the DIFC.
Yeah, before you go any further, the starting point for all of this is that the responsible management of family wealth is itself an Islamic obligation.
Yeah.
Nobody in their right mind would now conduct a major business not using an incorporated structure. So the question of using a structure has got nothing to do with your Sharia obligations. You have to choose the most appropriate one. And unless, therefore, you're using a structure for an inappropriate purpose, which is during time of death, illness, or on death, to depart from your obligations, broadly speaking, you are not only not being non-compliant with your Sharia obligations, you're actually being compliant.
Yep. So that was a very important question that the court clarified. Another important questions I found is this one, is whether the settler of a trust, whether it is permissible for him to be at the same time the shareholder or director of a company that is itself the trustee of the trust. Is that permissible? Well, the court clarified this too.
Yes. Yes, there's absolutely nothing in the trust law that says that a settlor can't be a shareholder or director of a private trust company, and indeed that's usually the position.
Yeah, and that again is another very important point in practice, because you will often see that in the concept of private trust company, and we touched before that the foundation could actually act as a trustee. So all this is coming together rather nicely with the court clarifying all these questions, so that now we know what to do going forward. Yeah, go ahead.
I just the further point that one of the issues, if you're explaining to a client what a trust is, and you say, well, it's all very simple, all you've got to do is you give your property to somebody else and the court will make sure that they act in accordance with the wishes you've expressed in the trust deed in relation to the property. That from time to time doesn't give much comfort to potential settlors. And the capacity to actually have a private trustee company as trustee, of which they are themselves a shareholder or director, resolves in the minds of many settlors concerns that the trustee might run away with the property. Yeah. So it's practically very useful.
Not only that, is also the fact that this jurisdiction has everything but licensed trustees. So it's not that many firms that are able to act as a trustee out of the DIFC for DIFC's trust in the first place. So I think this is, if only that, it solves the problem.
Yeah, but of course, unless you're being trustee as a business, you don't require to have a license, and you don't require to be registered. So.
Another question that I thought was interesting in terms of interpretation going forward is a number of families want to have a trust. They would draft a trust deed. They would won't make it Sharia compliant, and it happens. A mistake is made either by the family members, by the advisors. It can be a small typo. It can be something bigger. So the question is, what happens if such an inadvertent mistake takes place? Does it completely invalidate the arrangement, or can it be rectified? And here the court clarified something that was not surprising, right?
Yes. Well, when you say not surprising, it's not surprising because of the terms of the trust law, but in general terms, the law in relation to gifts is that the moving finger writes and having writ moves on. You can't go back and fix it. But that was subject to some clarification in English cases that started with a case called Re Hastings Bass, and ended, unfortunately, with a case called Fatah and Pitt. And the result of those cases in England was to very much limit the capacity of the court to rectify a trust to those circumstances where the parties were absolutely clear in what they intended to do, but having been absolutely clear in what they intended to do, then wrote it down wrongly. What that jurisdiction didn't permit you to do was to fix up a mistake where the parties had an intention in the sense of they wanted to give this property on Sharia compliant terms, but somebody misunderstood what the Sharia compliant terms were. And what the court has said in the context of the provisions relating to correction of mistakes is that if it's your intention to make a Sharia compliant trust and for one reason or other it's not, then the court can fix that, provided it's established as a matter of evidence that that was your intention.
Yeah.
Once again, it is a useful jurisdiction in terms of preventing people making unintentional mistakes.
Yep. And it's also ensures continuity of the tool. Yeah, if you can adjust it without breaking its spirit and purpose, then it's optimal. It remains what it is, but it's fixable. So that's a good news. Last but not least, a very important takeaway for the region for sure, because a lot of people today have or operate WACF that are, let's say, constituted somewhere else in the UAE, could be in another jurisdiction, and they are comfortable with the tool, but maybe they want to see if this could be recognized as a trust or as a foundation in the DIFC, or could it be continued there, possibly as a foundation. So that's very topical for the region. And here the court clarified that WACFs is an instrument that can take a lot of different forms, that it could be technically recognized as a trust if it is a WACF without legal personality, but if it's a WACF with a personality, then it could be recognized as a foundation. But the bottom line is, on a case-by-case basis, it is possible for a WACF that is pre-established to be recognized and or continued in the center, which goes in line with the general strategy of the center to allow a corporate migration and or shift of jurisdictional management of relationships. So again, something that was not necessarily a surprise, but I think it is very welcome that this is, although the specific question was not answered, a guidance note for practitioners that want to advise families that are relying today on WACF and that want to migrate to the center or make an evolution of the relationship for the family.
Yes, indeed. The point is, as you say, that it will be determined on a case-by-case basis. The court was not prepared to give an answer that would apply in every case, but the mere fact that the court didn't answer the question no emphasizes the point that this has to be decided on a case-by-case basis.
And we saw a lot of we will not answer, but in this judgment, which is why it is so useful. It provides tons of practical guidance for practitioners and end user alike. And if you have some more question on the impact of this judgment, respectively, any legacy planning, intergenerational structuring, asset protection using ADGM, DIFC tools. There's no better person than David Russell, with whom we often collaborate. So David, thanks a lot for taking out of your precious time to discuss this with us. I know you will be back in a couple of weeks to discuss the UAE mainland trust regulations. So we are all excited and bracing ourselves for this and see how it compares with foundations regime. And in the meantime, next week, standard program will resume, touching on something equally topical, which is how UAE foundation can be used for US planning. A lot of clients, 1 out of 3 per our records, actually has some sort of US element. So we'll see how these foundations can be used where there is a settlor or a founder that is a US national, a beneficiary that is a US national, or where there is US asset. We'll talk about this next week. David, thanks a lot. And in the meantime, I wish you a good week ahead. Bye-bye.
Thank you very much. Same to you.